Hi, so I'm going to be answering the ethical question whether um, unrepresented parties should be able to appear in courts and tribunals. Yes or no, why or why not? So I believe that unrepresented parties should be entitled to appear in courts and tribunals, and I'll elaborate in a couple of minutes. Um, it could go both ways. There's different points of view, like pros and cons for yes, they should, and no, they shouldn't. But I really support that they should be able to. Um, I believe that access to justice is a key value in every democratic society and a core component of the Canadian legal system. I think it guarantees that people have the ability to seek redress and protect their rights through the legal system. And throughout my essay, I will be talking about supporting the presence of unrepresented parties in the Canadian legal landscape, emphasizing principles of access, individual autonomy, and the need for a fair and inclusive judicial process. So, the foundation of Canadian democracy is the rule of law, and the rule of law is the highest above all. And Canada places a high value ensuring that all citizens have access to justice. The right to a fair trial is guaranteed under the Canadian Charter of Rights and Freedoms, which includes the right to be heard in court or any legal proceedings. So, allowing unrepresented parties is a critical for protecting these rights, since it guarantees that individuals may participate in the judicial process regardless of their financial resources or lack of knowledge. So this is actually a Section 7 right. So it actually puts together the Canadian Charter of Rights and Freedoms, which is our constitution, which is basically basically our what we live by, right, in Canada. So it's a very critical factor in our system, in our legal system. So also the legal system in Canada recognizes the autonomy of individuals to make choices about their legal representation. They may retain a legal representative or they may represent themselves, allowing unrepresented parties to recognize people's freedom to represent themselves if they so desire, demonstrating a commitment to individuals' autonomy and self-determination. Um, so this is from actually Ontario Rules of Civil Procedure, OREG 194/96, Rule 1-03. So also, sorry, just give me 1 second. I think legal representation can be costly. Therefore, preventing many Canadians from accessing justice. I think a lot of people think that they might need a legal representative to get access to justice, and they may not be able to afford it, and they may not be aware of like free government services, government assistance programs that we have, such as legal aid, um, and other like tribunal websites that may guide you on how to represent yourselves and get access to the justice that you need. So I think it's very important for Canadians to do research and also represent themselves if they cannot um, afford a lawyer, because that is basically practicing their right, right? So allowing unrepresented parties serves to alleviate the cost barrier, ensuring that people are not barred from obtaining legal remedies only because of financial restraints. Also, another factor to consider is procedural fairness, because it's an important factor in the Canadian legal system. It allows unrepresented litigants helps to a more inclusive judicial procedure in which everyone, regardless of legal competence, can make their position. Their inclusiveness is consistent with the concepts of fairness and justice. So this is according to a case. This is actually from a case, R.V. Cunningham, as Supreme SCR 331. And I talk about that more in my essay as well. And I think allowing unrepresented parties can improve the legal system's efficiency. While there are some difficulties that may emerge, the flexibility provided by self-representation may help simplify some cases, thereby by lowering expenses and causing any unnecessary delays in the legal system. Sometimes when a party may be confused if they should hire a representative or not, they may keep adjourning, causing unnecessary delays to both parties. And I think it's very important that you have that you have that choice, whether to self-represent yourself and do your own research, or get a paralegal or a lawyer. To summarize, the existence of unrepresented parties in Canada, courts and tribunals is critical for maintaining the values of access to justice, individual autonomy, and procedural fairness. So those are the three main points I talked about today. The Canadian legal system promotes a more open and accessible procedure regardless of financial resources by allowing citizens to protect themselves. So also there's, like I was saying, there's many options such as legal aid and a bunch of other, let me just see, I had it out here, like Your Law, Steps to Justice, Law Society Referral Service, the Great Library, Self-Represented Litigants Resource. There are so many complementary resources that a self-represented individual may be able to use. So those are the pros of self-representing yourselves. However, there may be difficulties in self-representing yourself too, such as misunderstandings with the opposing partner's lawyer. That's why I think we're having any communications from the opposing lawyer. I think it's very important for the opposing lawyer to have any communications written in writing to avoid any confusion. As per also the Law Society rules for practice management tips as well. I also think that there's more pros to self-represent yourself than cons. And honestly, I'm running out of time, so you can refer to my essay for more details. Thank you for listening.